Okay, we will start. Tolakele and Sam. Good evening, everyone. Good evening, colleagues. I see we have 235 already, with some still in the waiting lobby. And I think Tolakele is busy admitting the rest of our colleagues who are joining. But now that it's already exactly 6 o'clock, I'll start maybe with the house rules. Welcome, especially the new attendees. We always have new attendees to our webinars, which have been going on for some time. Thanks to Clinix Health Group. Clinix Health Group is a private hospitals company that owns 8 facilities, 8 hospitals, 5 of them acute care hospitals, 2 of them mental health care hospitals, psychiatry hospitals, you'll call them, and 1 a day hospital. And the company has been sponsoring these webinars for 4 years now, plus free of charge to all attendees. The webinars are accredited with the HPCSA for HPCSA CPD points, both for clinical CEUs and also the ethics CEUs. And the topic that we have today, as you can see on the screen, is actually will contribute to your ethics CEUs, which most of us need as registered with the OHSC MRI. I am Dr. Ernest Kinoshi. I'm greeting you on behalf of Clinix Health Group, and we welcome all attendees, especially the new ones. We hope you will remain, and we will always, on a weekly basis, we try to get to recruit speakers who gracefully are experts in their field. Some of them are not. They're still young specialists who are quite enthusiastic, well educated, and who would like to share their information with colleagues. And we welcome any of you who may choose to want to present in any of our webinars in future on any topic of your choice within any of the clinical disciplines. So you tell us what you want to present to your colleagues on, and we accommodate you. So you can contact us on Clinix, the email address webinars at Clinix with an X, Clinix with an X, as you can see in the labels behind you. Webinars at clinix.co.za. Webinars at clinix.co.za. We will put it in the chat box as well. So you can contact us on any matter related to our webinars, whatever you want to know, whether you want to offer yourself as a speaker in future, whether you want to offer any of your colleagues or principals, supervisors as a speaker, whether you would like to offer a topic that you want us to get a speaker on. You may want us to talk on any topic whether it's in obstetrics, in neurology, neurosurgery, orthopedics, or anything, psychiatry, mental health care. And we will try to accommodate wishes of people. If you've got any issues with the CPD points, normally they are accredited within about 2 to 4 weeks of your attending. You will get an email directly from HPCSA, not from us, from HPCSA, informing you of updating of your profile, your CPD points profile with the HPCSA. So when you register, you remember you gave us your registration number, and that registration number that you use when you register to obtain the Zoom link on which you are will be used automatically to once you attend. You don't get CPD points for registering. Some people register but don't manage to attend. So the system detects attendance. So those who have attended the webinar, the entire webinar will then automatically get confirmation of their CPD points between 2 to 4 weeks. We hope working on a system that may make it that time even shorter. But we had meetings this week with the HPCSA, and we're trying to get that right. But for now, 4 to 6 weeks, you'll get an email from us. If there's any problem, please drop us a line on Clinix at I keep on starting with Clinix, with webinars at clinix.co.za. Let me go to our speaker tonight. As you see on your screen, our speakers tonight is none other than Professor Christina Lundgren, who is well known to most of you. Many healthcare professionals throughout the country. I think, Prof, you've contributed so much to the body of knowledge in medicine and its governance. I mean, it's amazing. And we'll be glad to have you tonight. And we're glad that you are here with us to share your knowledge on various fields. Professor Lundgren received her MBHP from UCT many years ago. She went on to get a diploma in anesthesiology with the Colleges of Medicine of South Africa, and she went on to get a fellowship with the colleges of College of anesthesiologists within the college, and she didn't stop there. She went on to get a PhD with Wits University. She got an MSc later on in medicine, MSc in health law and bioethics, also from University of Witwatersrand. She's currently the head of clinical governance at Wits Donald Gordon Medical Center, which is belongs to University of Witwatersrand. Those who know the hospital, it's a complete hospital run by the University Donald Gordon, and she is there as a head of clinical governance at the moment, clinical governance and risk management. She's still an adjunct professor at the University of Witwatersrand, and she's still continuing with teaching and training, even post-retirement after 8 years of being head of anesthesiology in the Wits Charlotte Macheke complex in the Chris Hani. But also, she's also with the Steve Biko Center for Bioethics, which is also attached to University of Witwatersrand. She has received numerous national awards, including the Hugh van Ussel Medal, Honorary Life Membership of the South African Society of Anesthesiologists, and also with the Colleges of Medicine of South Africa, the Philip Tobias Distinguished Teacher Award, and the OVS Koch Award for Exceptional Contributions to Anesthesiology. Her leadership roles include head of anesthesiology, of course, I've just mentioned that previously. And she currently, she served as past president of the College of Anesthesiologists of South Africa. And also internationally, she has served as chair of the World Federation of Anesthesiologists Publications Committee. She's the deputy chair of the WFS Day Committee, and also editor-in-chief of Updates in Anesthesiology. Professor Lundgren has also been active recently with the Health Professions Council, served in a number of in the prelim committees of the council, and she's still contributing a lot to the Health Professions Council, and she remains a teacher of many. She has been an examiner with the Colleges of Medicine of South Africa, and she's got special interest in medical legal work. that's her expertise at the moment. I think so. We couldn't get a better speaker than Professor Lundgren to talk to us on informed consent, and especially the concept of ethical practice and the professionalism as is in relation to getting consent from patients, a problem that has been, we think it's a small topic, but you'll be amazed the number of cases that Professor Lundgren has shared with me personally about what happens when clinicians get into trouble simply because of and including nurses, by the way, on the issue of informed consent. Prof, I'm going to mute myself, but before that, I'm going to also let the audience know that during your speech, we won't be interrupting you. We will be muted, all of us, but at the end, we will have a questions and answer session. In the meantime, members may type their questions and comments in the chat box. So the chat box is open. You can put your answers and comments in the chat box, and Professor Lundgren will attend to them during the questions and answers session at the end. And during the Q&A, you will also be able to lift your electronic hand and be able to ask any question or make any comments orally if you'd like to do so. Over to you, Prof. Lundgren. I'm going to mute myself till the end. Thank you.
Thanks so much, Dr. Kanoshi. Thank you. Good evening, colleagues. Those of you who know me well know that I'm passionate about informed consent. And so if I talk too much or if there are concepts that are unclear, I'm very happy to take questions at the end. But I've learned over the years that we are not very good as healthcare professionals with informing our patients. So, and remember, it's all about patient autonomy, and I'll go into the principles, the ethical principles in a minute, but it's about patient autonomy coming from autos, which is self, and nomos is rule. So it's the right to rule oneself, the right to decide for oneself. And it implies liberty and capacity. So freedom from the control of others, and we've all had interfering families, interfering spouses, if we're trying to get consent in the theatre environment, consent for chemotherapy, blood transfusion, families, everybody thinks they have a right to get involved. But in fact, that's not allowing our patients patient autonomy. And capacity is the freedom from excessive personal limitations, and it behoves us to confirm that our adult patients have capacity. And I will mention children, but children and consent is a whole lecture on its own. So an autonomous action is acting intentionally, with understanding, with competence, and without any external controlling influences. Choices sometimes we need to remember are affected by ignorance, coercion, and incapacity. And a good example of choices being affected by coercion are, for example, with Jehovah's Witness patients, where a 16 or 17-year-old child would be quite happy to accept a blood transfusion, but has been coerced by parents or the minister of the church or whatever. So there are always going to be coercive elements that we need to be aware of. There are limits to autonomy, and individual limits I've already mentioned: immaturity, incapacity, irrationality, and ignorance. But that is dealt with in the National Health Act, which I will talk about later. And then there's certain community limits. So, for example, XDR, TB, or things like that. So endangering public health, potential harm to others, and then there's the competition for the limited resources. So limited organs for renal transplantation or other transplantation, etc., etc. So there are going to be limits of autonomy. Isaiah Berlin was a philosopher. He only died in 1979, but I think he put it very well when he said, "I wish my life and decisions to depend on myself, not on external forces of whatever kind." And I think when I think back on my internship at Barra in 1978, it was the bad old days, and we had no National Health Act, we had no constitution. All the good things that have happened subsequently were not in existence, and there was such a paternalistic attitude to consent. It was, I'm ashamed to have even been part of that era, but it was, I'm your doctor, I know what's best for you, this is what you need, sign here. And that is just awful. That is such an external force. It's such dreadful paternalism, and sadly it still happens in this day and age. But that's an example of a terrible external force. And he also said, "I wish to be the instrument of my own, not of other men's act of will. I wish to be a subject, not an object." And that we need to always bear in mind, even when we're stressed, even when we're in casualty in a trauma unit, that patients wish to be a subject, not an object. To be moved by reasons, by conscious purposes which are my own, not by causes which affect me. So the term profession means a dedication, promise, or commitment publicly made. And whatever our area of healthcare practice is, all of us or most of us will have taken an oath or made a pledge at some stage when we qualified and became a healthcare professional. And practice as a healthcare professional is a moral enterprise. And I know this sounds like I'm on a soapbox and I'm grandstanding, but it is a moral enterprise. And it's a lifelong commitment to sound ethical and professional practices. And the HPCSA, if you look through the ethical guidelines, and I think we're already up to booklet 19, which is on ethical billing, there are a myriad of superb documents of ethical guidelines. So, and HPCSA continuously reminds us that it's a lifelong commitment. And we need to remember the ethical practice in everything we do. So applying professionalism to consent issues, there needs to be mutual trust between the doctor and the patient, or the physio and the patient, the occupational therapist and the patient, the nurse and the patient. And we need to respect our patient's autonomy. We need to respect that they can decide, that person can decide for themselves. And one tends to not want to tell the whole truth, and particularly if it's an awful diagnosis, a potentially awful diagnosis. But it's very, very, very important for full disclosure. HPCSA emphasizes it. The Health Professions Act, under which all doctors practice, emphasizes it, as does the National Health Act. So patients need full disclosure, even if that conversation is uncomfortable, and sometimes it can be very uncomfortable. We need to remember to protect confidential information. We have the POPI Act, but irrespective of that, we need to protect confidential information. And I recall times at Barra where everybody sat in the tea room, anesthetic tea room surgeons, anesthetists, radiographers, whoever, and discussed patients. And that is just awful. We are not keeping privacy and confidential information as far as our patients go. and then be aware of possible confounding factors, and I'll mention that a bit later. So modern bioethics, there are four main principles in modern bioethics. And the most important one and a grounding ethical principle is autonomy. And that is the one ethical principle of the four that rests solely with the patient. The right to decide for him or herself. We are responsible for the beneficence, non-maleficence, and the justice. And sometimes it's our institutions, our laws that have a role to play in determining justice, but we are responsible for doing no harm and doing good. But it's the patient, the one principle that the patient has ownership of is autonomy. And well, they need to not only have it, but they need to have control of it. And one needs to remember that our Constitution emphasizes human dignity, and autonomy rests on human dignity. So if one does not allow one's patient autonomy, and whatever we're talking about, chemo, blood transfusion, whatever requires consent, central lines, spinal, epidural, etc., we are removing human dignity from our patients at the same time if we are not allowing them the autonomy that they are entitled to. And in order to allow patients to be autonomous, we need to give them sufficient information. And there's always confounding variables. Nothing is ever straightforward, as we all know. And somehow we've got to balance that autonomy from our own side with the beneficence and the non-maleficence. And we need to assist patients with making an autonomous decision. And the National Health Act and the Health Professions Act don't emphasize that the principle that's driving what is written in law is to assist patients with making an autonomous decision. And the big problem is very often there are adaptive preferences that may influence patients' autonomous decisions. For example, medical funders. In the private sector, if one has a medical funder who says, no, you have to go to that doctor, not that doctor, and we will only fund this procedure, not that procedure, etc., etc. Funders are already, in that scenario, affecting patients' autonomous decisions. And then very often there may be home circumstances, financial circumstances that may influence patients' autonomous decisions. So it's not only coercion from family, from friends, from neighbors, but it may also be other circumstances that are lessening the amount of autonomy that our patients have. So just a reminder of the laws that govern patients' legal rights to autonomy. First of all is our South African Constitution and Bill of Rights. We have statutory law, common law, and the HPCSA guidelines, which are exactly that, guidelines. But so they're not laws, but it behoves us all to practice bearing those guidelines in mind. The laws are, as I've mentioned already, the Health Professions Act. And remember, anybody who's registered with the Health Professions Council is obligated to abide by the Health Professions Act. The Consumer Protection Act, it affects one if one's practicing in the private sector or the public sector. The National Health Act, the Children's Act, which I'll mention briefly, and the Choice on Termination of Pregnancy Act. So there are numerous statutory laws under which we practice and which all allude to the issue of informed consent. So the Health Professions Act states that we are obliged to discuss all of the risks of our treatment, whatever we're going to do to that patient, legally and ethically. We're obliged to discuss the cost of treatment where it's applicable. And I've said the ethics of doing this on the red line because it's when I was first in practice, well, I didn't do much private practice, but we could bring major cases in the night before, and it gave one a chance to have a good discussion with the patient the night before. But times changed, and now a lot of colleagues have to have these sometimes difficult discussions on the red line or in the waiting area outside theatre. And somehow one needs to either give the patient to leave information sheets in the surgeon's rooms, or somehow one needs to communicate better with the patients. If there's no informed consent, does it constitute assault? And this is a very, very interesting topic. And I think if anybody's interested, there was an excellent editorial in the SAMJ, volume 113 in number 9 in 2023 by Siraj Khan, who's a practicing lawyer, but he's also a lecturer in the center, Steve Biko Bioethics Center at Wits. And this is an absolutely, it's only 2 pages for anybody who's terribly busy and thinks, do I have to go and read this? But it's food for thought and very, very interesting editorial. And it was recommended to me by Graham Howarth at the Medical Protection Society for anybody who's insured through MPS. And because I hadn't seen it, and he referred me to it where the wrong patient was anesthetized by a colleague, and he said, go and read this article. So when I asked him for some advice. The Consumer Protection Act is very, very interesting, and it applies, as I say, to the public sector as well as the private sector. In the private sector, one needs a written quotation or an estimate, which needs to be given to the patient for whatever it is you're going to do to them, whether it's R500,000 worth of chemo and 12 treatments, or whether it's physio, occupational therapy, etc. It should be a written quotation, and one may not charge more than that written quotation. If it involves surgery, this financial consent needs to be obtained preoperatively, preferably in writing, and it can be obtained by another person acting on the patient's behalf. So that's the only time really, apart from unusual situations, where another person can obtain that consent. And it's quite difficult in situations or in specialties where billing is time-based, because you're estimating how long a procedure should take and not taking into account any complications. So it can be tricky. The National Health Act of 2003 should be one of our go-to documents for informed consent. Chapter 2 of the National Health Act deals with informed consent, and it states that every healthcare provider, so not every doctor, not every nurse, every healthcare provider, so it's fairly broad, must obtain a use of the following: their health status, unless there's evidence that it's not in the best interest. And the family saying, no, don't tell granny the diagnosis isn't good enough. There needs to be evidence that it's not in the best interest of the patient. the range of diagnostic procedures and treatment options available, and that is incredibly important. So it's not just you must have this drug or this treatment and that's it. Because the longer I'm in medicine, the longer the larger the range of diagnostic procedures and treatment options are available. So one needs to take that into account. The benefits, risks, costs, consequences associated with each option, plus the user's right to refuse health services. And remember, patients, once you've given them all the information, they can say, leave me. Lost my 8. I don't want this treatment. I don't want this operation. I don't want whatever you're proposing. But one needs to explain the implications, risks, and obligations of such refusal. So that is quite important. And we had a very interesting case at Barra many years ago where a patient refused surgery. The complications of her condition were explained to her. She said, then I'll live with that. And she developed those complications. And then she did not have capacity to give informed consent. So the family brought her in and wanted the doctors to do what they were originally going to do. And she had previously refused in writing, so they could not perform that procedure because she had previously refused it when she was of sound mind. So it's very important that we explain the implications of refusal. And the last point in this section of the National Health Act is probably the most difficult, and that is this. The information must be communicated in a language that the user understands and in a manner that takes into account literacy. And this still remains, for me, one of the big challenges in obtaining full informed consent. I hope all the doctors present have indemnity insurance, because you never know when something can go wrong or when a patient might report you to the Health Professions Council for something seemingly trivial, but and then it's very reassuring to have one's indemnity insurer. But those who, well, the MPS website, there's a section that's not only for members, and they have a very good section on informed consent, Medical Protection Society. And they emphasize that obtaining informed consent for whatever it is, whether it's a surgical procedure, something medical, chemo, blood transfusion, etc., it's a process. It's not just a one-off. And a lot of doctors give their patients an information sheet to which a consent form is attached. They say, go home, read it, ask, formulate questions, speak to your family, whatever you want to do, and then come back and, decide yes or no, you're going to have this form of treatment. The decisional capacity one needs to decide. So a patient needs to be over 18. Decisional capacity one needs to decide. And that's usually fairly easy. Then the description of the proposed anesthetic, surgery, medical treatment, whatever it is, does the patient understand? And patients need to be given time to ask questions. However trivial or silly they might sound to us, they need to have the time to ask questions. They then make a decision and communicate in writing. Now, telephonic consent is ethical and it is illegal, but MPS and HPCSA advise us, for example, if it's an emergency or life or limb situation, get informed consent on the phone, but put your phone on speakerphone and have a witness, and then write in the patient's notes that you obtained informed consent from XYZ and it was witnessed, and then you're completely covered. But obviously it's always better to have it in writing. Excuse me. And then remind the patient that consent can be withdrawn at any time. And then once again, remind them and explain the implications of withdrawing that consent, because that's part of the whole information algorithm. The Children's Act of 2005 is a phenomenal act. It was only enacted in 2007, but it's an amazing act, and it applies to all those under the age of 18. And just a reminder, I've only got 3 slides on the Children's Act because it's a whole lecture on its own. But a child may consent to his or her own medical treatment or to the medical treatment of his or her child if the child is over 12 and the child is of sufficient maturity and has the mental capacity to understand the benefits, risks, social, and other implications. So this was, why was 12 chosen? Because the age always used to be 18. And in the Child Care Act, which was replaced, the Children's Act replaced the old Child Care Act from 1983. And this was because of the many child-headed households in South Africa. And we all know there are children who are older than 12, going on 21, who are streetwise, worldly wise, and can understand, they have the maturity, the mental capacity. And then we know of children who are 14, 15, and are certainly not mature and would not be in a position to understand the benefits, risks, etc. of a treatment. So this is the most challenging aspect of children for whatever treatment they're coming for. And there are no guidelines. The HPCSA has some guidelines on how to gauge capacity in children, but it's the individual doctor or healthcare professional who's going to do whatever administer whatever treatment to that child to decide if that child's of sufficient capacity. So that's for medical treatment, which is very broad. Whereas surgical treatment, the same applies, but the child needs to be duly assisted by his or her parent or guardian. And it's important. So if the child is mature enough, we are advised that the child signs consent and the parent signs assent. This is purely for surgical, and it says a surgical operation. If the child is not mature enough, then the parent or guardian signs the consent and the child assents. But, one gets teenagers coming for wisdom teeth extraction, dental work, and they're 15 going on 21, and all their friends have had wisdom teeth extracted, etc., etc. They are mature enough. They understand the implications. They can sign their own consent, but need a parent or guardian to sign the assent. So you need 2 signatures. And that's not my advice. That's what we've been advised by the law and people like Medical Protection Society and other indemnity organizations. And then just one last slide on children, because as I say, it's a whole subject on its own. Remember, once again, it's a process. If it's an emergency, the hospital superintendent can give consent. If it's, controversial for whatever reason, one can go to the High Court. And remember, in the smaller towns, the magistrates' court can function the magistrate acting in the best interest of the child. So a magistrate's court can fulfill the function of giving informed consent if there is no high court in that town, or the Minister of Social Services, but I'm not quite sure about getting hold of the Minister of Social Services, so it might be easier if one needs to go to the court. But remember, at all times, we must act in the best interests of the child, and I can't emphasize this enough, ethically and within the law. The Choice on Termination of Pregnancy Act has been around since 1996. And it's sad that, well, when I was in the early days at Barra, in the late 70s and early 80s, we had so many patients that came in with septic abortions, because we didn't have the Choice on Termination of Pregnancy Act, and it was tragic. They ended up in ICU. Oh, it was awful. And so this act, I think, is phenomenal. So it states, and this is very abbreviated, but a pregnant female of any age may consent to the termination of her pregnancy, and her identity must be kept confidential. Any age. And then I've really summarized this, but if she's less than 12 weeks pregnant, all females can have their pregnancy terminated. Remember, the institution must have ticked all the boxes in terms of the Department of Health to be allowed to perform TOPs. So not every clinic or every healthcare facility can necessarily terminate a pregnancy. That the onus is on the healthcare facility to have been, I don't know if it's a specific license or just a permit to perform terminations. From 13 to 20 weeks, the provisos are if the girl was raped, a risk of injury to the mother or the fetus, and socioeconomic circumstances. So it covers, it's pretty broad. But over 20 weeks, as we know, that's quite a large baby. Only if the mother's life is threatened, risk of fetal injury, or if there's a known malformation. If the child is a minor, under 18, if the girl is a minor, they're advised to consult with their parents, but they don't have to. And it's not for us as healthcare providers to go phoning the parents. The minor is advised to consult, but does not have to. And that's, if one has children of one's own, that's quite a tricky one. But that's what the Act says. If a woman's severely mentally disabled or continuously unconscious and pregnant up to 20 weeks, the guardian, spouse, or legal guardian can consent. And then what about procedures resulting from the termination? So something goes wrong with the termination and the patient bleeds a lot, needs a transfusion. In rare cases, patients end up needing hysterectomies, all sorts of dreadful complications. And it's been tested in court, and I know there have been quite a few cases in KZN, and our legal colleagues all say all procedures resulting from the termination are covered by the original consent. I think if one has a child, if one has a minor child, I think one would be more comfortable if a parent or guardian at least knew about it. But, you know, the lawyers say that procedures resulting from the termination are still covered. And the other issue with TOPs is if staff have a religious problem or a religious aversion to terminations of pregnancy. It's been challenged once again in court, and one just needs to be sensitive to our colleagues and have somebody else perform the termination. So one can always get around it. Now, the important things are the proxy consents, and in adults especially. So with a child, as I mentioned, if it's an emergency, the superintendent of a hospital can give consent. Otherwise, it's the court or the Minister of Social Services. That clause is not in the National Health Act from the point of view of adults. And so the proxy consents that are listed in the National Health Act are as follows. If the patient's got a power of attorney, given a power of attorney to someone, if it's been mandated by a court for whatever reason, and then a spouse, partner, parents, grandparents, adult child, brother, sister, in that order. And it says that in the National Health Act, in that order. So it's important. And nowhere does it say hospital manager, hospital superintendent, or any, it does not list any of them as proxy consent givers in the National Health Act, which covers adults. So what about the HPCSA guidelines? And they've got a section, and you can see it's probably been written by lawyers, but their section on informed consent is that for proper informed consent, the patient must have knowledge of the nature or extent of the harm or risk. And sometimes this is difficult. You don't know, the patient's never had penicillin before, you don't know if they've got penicillin allergy or anaphylaxis. So, I mean, there could be unexpected complications for whatever major or minor treatment you are giving that patient. So one needs to have a system of how much you tell the patient and how you tell the patient. Appreciated and understood the nature of the harm or risk, and that's often where language and literacy may come into play. And then they must consent to the harm or assume the risk. And it was quite interesting during COVID and severe lockdown, a level 5 lockdown. At the Donald Gordon, we modified our recommended consent form to include sharing the COVID risk. So the doctor and the patient shared the risks associated with whatever it was, procedure during the COVID era, and the patients were informed as such and assumed the shared risk. And then the consent must have been comprehensive. I mean, this is legal jargon, but extended to the entire transaction, inclusive of the consequences. And which risks should we tell the patient? You know, and in anesthesia, which is my specialty, you know, do you tell the patient they might die? Do you tell them if they're having a spinal, they may develop a spinal hematoma? The incidence is 1 in 50,000. You know, what do you tell the patient? And we are advised that known risks should be disclosed when an adverse outcome is common. So I always used to tell all my patients who were coming for a GA that they wake up with a sore throat. And then if they didn't, then that was great. But that's easy in anesthesia. But so the detriment is usually slight there. Or when an outcome is severe, even though its occurrence is rare. And that is the important part. And that's often the tricky discussion that some of us avoid with our patients. The most important aspect of which benefits, risks, and consequences we discuss with our patients is if a patient says, I don't want to know, do whatever you have to do, that invalidates the consent because it is no longer informed. So somehow one needs to get around that. And I honestly think information sheets and more comprehensive informed consent forms that the patient can take home with them will prevent this, I don't want to know. Because if something goes wrong, that's the first patient who will institute legal action against you. So what does the HPCSA say about the risks? And the most important in this advice from our Health Professions Council, and I'm sorry if the nurses on, I'm sorry I haven't got the Nursing Council, the SANC guidelines. I'm not sure if there are guidelines on informed consent, but I know that the allied health professions are all covered by the HPCSA. But the HPCSA has said South African courts have held that patients must be informed of all material risks. And what is a material risk? And you'll hear lawyers talk about material risks. And a material risk is if a reasonable person in the position of the patient is, if warned of the risk, would attach significance to it. So, you know, you might bleed. If you're having a transplant, you might, you know, your body might reject the transplant. You could die, or it could be a minor risk. And we need to be aware that the patient, if warned of the risk, would attach significance to it. And so another way of looking at it is the reasonable doctor obtaining consent from a reasonable patient will discuss the material risk. And so one needs to put oneself in one patient's shoes. Whatever the treatment is that you're going to administer, is that, are those risks reasonable to you? And in turn, are they reasonable to the patient? One needs to give a balanced view of the treatment options. And then, as I mentioned earlier, the known risk should be disclosed even when an adverse outcome is common or when an outcome is severe, even though it's rare. And somehow in one's practice, whatever one's practice is, one needs to frame the risk. So don't say common, don't say rare, because a lot of patients don't understand that. And you know, I mean, as an example, I used to say, they'd say, what is the risk? Might I die from this anesthetic? And depending on what the procedure was and what the anesthetic was, you know, the answer could be, you've got more of a chance of dying if you drive to Durban on the Thursday before the Easter weekend than from this procedure. Or from this anesthetic. So it's just contextualizing it with the patient, and it really does depend on your patient, and obviously in the case of children, with the parents. And then ask the patient if they understand. And a lot of hospitals, private hospitals, have got this confirmation of consent form. And for those who work in hospitals where they've got a confirmation of consent form, firstly, it's not a legal consent form from our practitioner point of view. But secondly, I don't know if any of you have read what patients think they're coming for. I remember I did an audit of the confirmation of consent forms, and I saw some neuro patients who were coming for the most amazing, weird and wonderful procedures, and that I don't think they understood fully. So it's very important to check that your patient understands whatever treatment you're going to administer to them. Be prepared to answer questions and then formalize the disclosure. And this is where I think information booklets come into play, an app, possibly preoperative assessment clinics. And remember, we are all competing with Google and all the ChatGPT. Oh my goodness, patients know everything from ChatGPT. Wikipedia, whatever. They go online, and I was once given a coffee mug that said, "Don't confuse my medical degree with your Dr. Google." But quite honestly, with all the AI programs now, and for example, ChatGPT, patients just plug in a whole lot of things into it, and out comes what should have happened, what should have been done. did they give consent, etc., etc. So we've got quite an uphill battle when it comes to the internet, and which is why it might be better to give the patient your consent form to take home and bring back with all their questions. And don't be surprised if the questions are ChatGPT generated. So above all else, remember that autonomy rests with the patient. And that is the only one of the 4 principles in modern bioethics that truly rests with the patient, even if there are other influences like funding, like families, etc. It's the one principle that rests with the patient. And it's linked to human dignity. And we need to remember that at all times. We need to assist our patients, and as I said earlier, adaptive preferences may influence their autonomous decisions. Act in the best interest of the patient, and sometimes when one's in a tricky situation, and it doesn't always just entail informed consent. There are all sorts of tricky situations that medical practitioners can find themselves in. And you just need to step back and say, what's in the best interest of this patient of mine? And that needs to be our governing principle, be it an adult or a child. So in summary, it's our ethical and legal duty to obtain informed consent. So the law says we must do it, and our ethical guidelines state we must do it. Respect our patient's autonomy, even if it has limits. Full disclosure, respect confidentiality, make sure the consent is informed and voluntary, and allow the patient to withdraw consent. And that is quite a tricky one. I thank you.
Thank you very much, Professor Lundgren. I think that was a mouthful. I think this was a wonderful lecture, very clear and clearly given to us. And I really appreciate your presentation. I think it's a lecture that many of us hope that even all our colleagues in the country would have heard. And I'm sure we can make this available if you give consent. So there are questions in the chat box. Thank you very much. And there's one of them, actually more than one, ask whether they can obtain a copy of the presentation. So my answer is that presentations are the property of the presenter. So myself and people within Clinix Health Group don't have the power to share presentations of the speakers. We respect that, and if there is any request, we pass it on to the speaker, and then we send to the individual presenter. We don't send it to all, but we send it to the individual in PDF form on request, and we requests are on at webinars@clinix.co.za. So you drop an email to webinars@clinix.co.za. Myself, Tolakele, Sam in the background will assist you with consent from Prof Lundgren. Prof Lundgren, you wanted to say something?
Dr. Kenoshi, you've got the PDF of my presentation with pleasure.
All right, thank you. So anyone who would like to have a copy may do so. There are some who've written in the chat box requesting attendance register. So I saw one such comment. Yes, we can give you proof of your attendance. Also, if you ask that you have attended, we give that to the HPCSA. We can see on the system how long any of you had logged in. So the system, I think it's automatic, as you can imagine. And so those who had managed to register and log in will first of all, we'll notify the HPCSA about it on your behalf automatically within a few days. But also, if any of you require proof of attendance, please drop us a line on webinars@clinix.co.za. I must say that I think there's one question from someone who said they attended last week. Is it Dr. Nkasela, who says they attended a week ago and they still haven't received proof of CPD points. As I said earlier in my opening remarks, people should expect HPCSA to update their CPD points profile within 2 to 4 weeks. So it takes about 2 to 4 weeks for the system, because we notify HPCSA through the system of all attendees, and then they go through their processes to allocate those points to individual doctors. You can imagine it can be done in one day. I mean, we had so many people today alone at the top of attendance, Prof. We had accounted 706 attendees today, which is sort of a record on its own. Yes, I think at the moment we still have 668 or 686 or so still online. So it's quite a number. I think so. It's quite a lot. So we have to deal with them. But I should also say to attendees that only those who register with their HPCSA registration numbers, your HPCSA number, will be recognized for CPD points. So if some people still make the mistake, and I think this has been repeated by so many, unfortunately, that they write their practice number. You know, your BHF, Board of Healthcare Funders practice number doesn't help, because that's for your practice. But your HPCSA is your registration as a practitioner, and that's the one that HPCSA uses. So please, on the registration form, the electronic form that we send out, takes 2 minutes to register your name, HPCSA number, your number, and whether you are registered as a medical practitioner or whatever other health profession. I think you'll be covered. There is one question, Prof, from I think it's an enrolled nurse, and I think those are registered with the Nursing Council. And I think if your Nursing Council requires your attendance, if they also have a CPD point system, you can also let us know, write to us, as we Tolakele responded to you, that you write to us and we will give you a proof of attendance individually. Thank you, Prof. We'll go through some of the questions. If any of you would like to put your question orally, you may raise your hand, and myself, Tolakele, and Sam will recognize you, and you'll be allowed to unmute yourself, and you can put your question or comment orally. But maybe let me start with this one. I think it's Dr. Martha Swart. I think there was another Lane Marilyn. I think several names. You pardon me if I'm getting your name right, but I'll paraphrase the question. It's about concern in cases of mental health with mental health care patients, and what do we do there? And then there was a comment, and I think it was in response to this, also in the chat box from somebody I know very well, Professor Gerard Grobler. Professor Grobler is the head of psychiatry at the University of Pretoria, Steve Biko Academic Hospital Complex. So we know each other quite well. Thank you very much, Prof, for having logged in. But you say in the chat box that you say, I'll be able to assist with this. We recently published a textbook with the algorithm to assist non-specialists in mental health care. Thank you for that. So you may contact either Professor Gerard Krobler directly, or you can let us know, and then we can assist with the contact with Professor Krobler on your question, Dr. Swart. Thank you very much for that. Prof, there was a question on
radiology.
I think if Prof Krobler want to go on that one, I think he can also say so, and then we will recognize him and unmute so that if he wants to comment on consent in the case of mental health care, Prof Krobler. And Tolakele will assist me if Prof Krobler
I think it's easy. I think it's easy if the patient's been committed as a mental health care patient, because then the Mental Health Care Act specifies the consent. The difficulty is in patients who haven't been committed as mental health care patients. And I'd love to see Prof Krobler's book, because those are the very tricky ones, trying to gauge if those patients have capacity to, I'm talking about adults, to have capacity to give informed consent.
Yeah.
But I'd love to see his book and hear from him.
Yeah. If Prof Krobler is still in the meeting, please, you may. Yes, Prof, yeah. Go ahead.
Good evening, Dr. Kanoshi. It's nice to see you again. And Prof Lundgren, thank you for your informative talk. The issue is very much capacity to consent. And so the law is very clear on the grounds for involuntary admission. We have moved away in the new Mental Health Care Act of 2012 from committing people to voluntary assisted and involuntary care.
Yeah.
And so the key issue there is to what extent and how does the mental illness impair the person's capacity to consent? And to what extent does that impair the person's willingness to receive treatment? And that is exactly what the algorithm is about. It is a practical application of the current requirements of the Mental Health Care Act. I'm happy to discuss that, and I'll give more information, if you'd like to have a webinar on that. But it's set out in the book, and there are cases on which you can practice applying the algorithm that we've developed. It's called the Incapacity at Legal Status Assessment Algorithm, ILASS.
That's fantastic, because capacity is sometimes, there's a very fine line in some patients.
Thank you very much, Prof, for your information. I think people are free to follow up with you, and I'm sure they are keen also to obtain your book. I'm definitely keen to obtain
So am I.
Thank you.
Thank you very much, Prof. There was a hand from someone, but now I see the hand has disappeared. Sorry about that. Tolakele, did you see there was someone wanting to raise an oral question or comment? I don't see them anymore, but you may do so. Maybe they were answered. But there's another question. Prof Lundgren, from Dr. Mohammed Abdul Rahim. When we have a scenario where there's a language problem and the patient speaks to the doctor, I'm paraphrasing, and the patient speaks to the doctor through a family member or a friend, or on confidential medical situations, like in the case, let's say, of HIV, how do we go about handling this without breaking confidentiality when a patient is accompanied by a family or friend? Dr. Meshri Naidu, we can recognize your hand. Please keep it up like that. We will come back to you after Prof has responded to this question. Thank you. Go ahead, Prof.
Then what needs to happen before the HIV topic is even broached is that we ask the patient via the translator, via the interpreter, if they're prepared to discuss confidential information with that person, and that it may entail all sorts of illnesses, and are they prepared to do it, and if necessary, get them to sign that they are prepared to discuss confidential matters, however you decide to do it. And then you continue with because if you're going to discuss HIV positive results, that patient should have been counseled before they had the HIV test done in the first place. I mean, there's a very strict protocol for HIV. So, but then that patient needs to have one in person who's an interpreter, and it can't be a random member of staff or somebody. It needs to be one person where they are happy that that person knows their confidential information, and then you go ahead. And if it's verbal or oral, then get a witness in just to witness the consenting part.
Okay, I hope you've been answered. I think
can I answer the question above it, Dr. Kenoshi? It's quick. The radiology.
Please do.
So in radiology example, a CT, who's supposed to get the consent from the patient? Is it the referring doctor, radiologist, or the radiographer? It's the radiologist, because the radiologist is the one who reports on that CT. So the referring doctor literally refers the patient for a CT, but the CT, the consent is obtained from the radiologist, takes the responsibility for the informed consent.
Okay, thank you very much, Prof. I think let's go to there's a hand from Dr. Mishri Naidu. Dr. Naidu, you may ask your question. Please go ahead. Tolakele, please assist with unmuting, please.
Hi.
Hi.
Yes, please go ahead.
Okay. Good evening, everyone. Thank you for a very informative talk. I am an occupational therapist who is hospital-based for many, many years. And we often have patients who are unconscious, and we are confined to contacting the next of kin, which the hospital has added to their records. In doing so, we are unable to follow the hierarchy of getting the family member, for example, grandparents, etc., to give consent. So we are confined to just the name given as the next of kin, and we follow that procedure and contact that person. And sometimes the patient won't want to give consent if they are on another family member's medical aid, which might be a sibling, not a sibling, a child, which is lower down on that hierarchy that Prof showed us. So what I want to find out is, given that scenario, am I doing the right thing?
So the answer is yes, because it's the patient's unconscious. So, and I mean, the hospital has done well in getting a next of kin person. It's worth asking what their relationship is to the patient when getting consent, and then just document it, that was the only next of kin available because the patient was unconscious, and then you document it.
Okay, that makes sense. Thank you so much.
Yeah.
Thank you very much.
Can we
go? Can you go to Dr. Thabo Mashego? Dr. Mashego, I think you were next. You can put your question or comment to Prof Lundgren. Is it Dr. Mashego? We have quite a number of questions, so I think we have to go through this quite quickly. We can go to the next one if Dr. Mashego is having a problem. Tolakele, I think there was another hand.
Dr. Mashiko, you may please.
Hi, how are
Yes,
you?
please go ahead. Please go ahead.
Okay.
Thank you. Good morning.
What a topic. The first question is, can you differentiate between informed consent and assenting? That's number one. Number two, is assenting also a legal document or is only an ethical issue? Number three, are you still going to follow the same processes as you do the informed consenting? Like we'll define the operation, the benefits, the risk associated with the operations and everything. Thank you.
So
Right.
assent is the same as consent, but it's the second person, it's the second consent, as it were. So just so that there's no confusion, there's a primary, and this is children, there's a primary consent giver, and that's either the child over 12 who understands and has sufficient maturity, etc., and they give consent with the parent giving assent, but the parent is agreeing. And I see there's a question, what happens if the patient, if the parent disagrees, but the child wants the op and the child is mature enough, then you still do what's in the best interest of the patient. But if it's elective, the best thing is that we had one at Barra, a child and it wasn't elective, he had a torsion of the testis, and the mother had signed consent. He was 15 or 16 and he refused, and we sent the mother and the child were in the ward, and we sent one of the anesthesiologist consultants down to explain it all, and then the child said yes and the mother said yes and the child came back. So very often, if it's urgent, you do what's in the best interest of the child. If it's not urgent, try and get the proper information session and then do it.
Okay.
Then you asked, so assent is both of them consenting, but it's easier if one calls one consent and one assent. So it's much of a muchness. I can't remember. I didn't write your questions down. Sorry.
Yeah, and I think he had 3 questions, but they're all related. I think you've answered most of them. I think maybe let's.
Okay.
Thank you. Can we go to this one, especially on children? What is the cutoff age? Is it 12? And if
12.
If 12, so once is it now? So 11 cannot give, but 12 can give.
Yeah. So 11 can't give for medical or surgical. Over 12 or over can give for medical and can give for surgical with the assistant if they're mature enough, etc., and have the capacity, and with the assistant of a parent or guardian. So they can't give consent on their own for a surgical procedure.
Yeah, there's a question from Dr. Thabo Motabeng, who says, is verbal consent no longer valid? Verbal consent, as opposed to
verbal. I did mention that verbal consent is valid, but have a witness. So if it's verbal consent on the phone, have your phone on speakerphone and have a witness and write it down in the patient's notes. Otherwise, if it's face-to-face and it's verbal, it's fine as long as it's informed, and write it in the notes that you obtained verbal consent. So it is still legal as long as it's informed. But the HPCSA and all our indemnity organizations advise written consent.
Okay, great. I think the audience will excuse us because we are going to go quite fast. We want to cover as many of the many questions that there are there. I don't think we'll be able to cover them all within the next 15 minutes or so. But there's one that's from Dr. Mkalipe, which says, if you receive a subpoena to release medical information of a patient, are you expected to obtain consent from the patient before you release the information?
So there's the POPI Act, which advocates confidentiality, but then there's the PAIA, P-A-R-A, Protection of Access to Information Act, where patients are entitled to their own records. and that allows patients to ask for their own records. If you are subpoenaed to give records, I would let the patient know that you've been subpoenaed to give their records, because with both of those laws, and especially the newer PAIA Act, it's plus the POPI Act, where the information is confidential, you should ask the patient, inform them. But I mean, you can't ignore a subpoena, so they need to understand that.
Yeah. All right, thanks. There was a hand from Dr. Matlante, but I see he has lowered the hand, so I'm not sure whether he still wants to ask the question or whether his question has been answered in the process. But let me advise those who raise their hands should keep them raised. It's just an electronic hand, so you don't get tired. And then we will come to it, so don't be impatient, because there are lots of other questions as well. So please, if you raise your hand, please keep it raised. Dr. Matlante, do you want to come back? You have been answered, because you had raised your hand for some time. And okay, you'll raise it again. Let's go on with the. There is a hand up now. Tolakele? Tolakele, please respond. Is there a hand that you see on your side?
There isn't a hand, Dr. Kinoshi, on my side.
All right, that's fine. Thank you. Let's go to I'll take them in at random very quickly. Some of them are sort of a repeat of a previous question. There are many Prof who say how informative your talk was, and I think that's very important. There's one from Victoria Hospital Boardroom. Let me read this one out. Understanding the Child Act in regards to consent. What? Just bear with me.
When there's emergency that needs to be done, a child younger than 12, but the mother or guardian refuses, how do we deal with it? I would then involve the hospital manager / superintendent, and if necessary, go to the children's court. So if you're in a small town, the magistrate, get legal advice. But with an emergency procedure, if it's life or limb emergency, and you need to do what's in the best interest of the child. So if it's life or limb, you act in the best interest of the child. If it's urgent, but the child's not about to exsanguinate or whatever, get the hospital manager / superintendent involved, and then if necessary, if you're in a small town, as I say, the magistrate or the children's court judge who's on call.
Tom Tabeng comes back and says, one assumes that withdrawal of consent for procedure can only happen before induction of anesthesia in the procedure. You want to comment on that? Okay.
Yes, but there's a question, what happens if the patients receive the pre-med, then decides they don't want the procedure? That's a tricky one, but I would not go ahead and do the procedure if they've had a pre-med. I don't know if the pre-med will obviously have affected their capacity, but some people have a pre-med and are still absolutely fine. So you need to gauge, but rather err on the side, if it's an elective procedure, err on the side of caution. Don't do it, have another discussion with the patient. So that would be my advice. But I sound like I'm fence sitting, but I would, even after a pre-med, I would be conservative with not going ahead with the procedure.
There's one related question. I'll take it because it's related to the question of withdrawal of consent. It's from one Dr. Vidumela Kinoshi. What are the financial implications when a patient withdraws consent on the operating table just before the administration of general anesthesia or sedation? the financial implications.
So yeah,
there would have been cost
they would have
incurred.
So I would have thought that. So if hopefully one's talking about private practice, so hopefully the costing's been discussed with the patient in terms of the Act, the Health Professions Act and the Consumer Protection Act. So then the patient, they can refuse, and you can say, well, you understand that there are going to be costs. You've been admitted, etc., etc. So you're entitled to refuse the surgery, but it does have cost implications. Yeah. So I think that's fair to the patient, as long as you've had a cost discussion before all of this happened.
Okay. Dr. Mokoko Mateka, who is a psychiatrist, I know, says, I think you've answered this question actually, about a minor, from Jehovah's Witness who requires blood transfusion. I think you did deal with it, am I?
Yeah, right? I did.
In your presentation, Dr. Mateka? Yeah, okay. Unless if you want to say one word, maybe with it, without spending much time, Prof, if you want to repeat in case people might have missed it in the presentation.
The Jehovah's Witness.
Not just Jehovah's Witness, but for religious reasons. Let's put it that way.
So if you speak to people who are Jehovah's Witnesses, I mean, there was a story, I think it emanated from KZN, where they said if it was in the best interests of a minor to receive a blood transfusion and you gave it to them, the child would be ostracized by the family. Then we addressed that with members of the Jehovah's Witness organization, and they said that was nonsense. But it is a concern. Remember, you always need to act with a minor. You act in the best interests of that minor. And if you can get the law on your side, if you can get the children's court on your side, so much better. But you act in the best interests of the child, if it's an emergency setting.
Yeah. I think it's Dr. Yusuf Mula who asks, can a medical practitioner witness the consent of another medical practitioner for a procedure, whether it's blood transfusion or contrast administration or CT scan or whatever?
As long as they're not the assistant or helping with the procedure.
All right. Because he says in his institution, only need a nurse who can witness, or can it only be a nurse? In our institution, 2 witnesses are required if in the above mentioned situation. I suppose it's a local rule there. Do need to have 2? Yeah.
No, not necessarily.
So as long as the person is not part of
the team, yeah.
That's right. Professor Makunyane, your colleague, a colleague in another forum, Professor Priscilla Makunyane, Sipati, thank you. She's asking, one of the ethical dilemmas I have encountered involved in child with an ocular malignancy requiring a mutilation. Although the mother consented to the procedure, the father refused. And for this serious condition, he further threatened legal action. Could you kindly advise on how such situations should be managed, where one parent agrees, the other doesn't, and it's as serious as malignancy?
So the Children's Act says a parent or guardian for starters, and there's a document produced by UCT on guidelines to interpret the Children's Act, and it's quite detailed on is the father really the father, or is he a part-time father, as it were? There's all sorts of, now I know it sounds funny, Dr. Kinoshi, but there's all sorts of scenarios that are painted, and quite honestly, in this, the father can threaten. If I was in this situation, you need to act in the best interest of the child. If the mother consented, I would inform the hospital manager, and if you can, get the children's court, get a judge from the children's court, but they'll be guided by, say, because it's not urgent, so you can get the judge on call for the children's court, and I'm sure that judge would say you act in the best interest of the child. Because it is a problem where you've got parents fighting each other. And I mean, this is in the best interest of the child to remove the ocular malignancy. But I would inform the superintendent to get hold of the children's court judge who's on call, and just get him or her to say, of course, you do the enucleation or whatever procedure is going to be done, because that's in the best interest of the child.
Yeah. Dr. Mutlante's question may not be related to today's topic, but because he had raised his hand earlier, but I see he's put it in a chat. He says hospitals will waive co-payments, but providers will send patients massive co-payment money. Why can't they work together? I know this is about co-payments, and like I said, it hasn't got any relation to the topic, Prof. But I think if a
it's
hospital,
covered, yeah. Dr. Kinoshi, it's covered quite well in booklet 19, the ethical booklet 19 of the HPCSA that was published, I think, last year or the year before. But the billing, the ethical guidelines to ethical billing practices is because you may not have split billing. Split billing is unprofessional and unethical. But you can send one bill, the same bill, to the medical funder and to the patient. But it's covered, the ethical conduct with regards to this whole co-payment thing is covered quite well in ethical booklet 19. I've been through it, Dr. Kinoshi, but it was a good 6 months ago. So I don't want to quote it.
All right. I think Dr. Mtlante just get hold of the ethical booklets. The ethical booklets of HPCSA are available on the HPCSA website, fortunately for all practitioners. Just search through it. There are links to the ethical books. You can Google correctly. You will get there. If you have a problem, you can always let us know. Let's take a question from Dr. Peggy Sekele. Good afternoon, Peggy. Nice to see you attending again. Dr. Sekele's question is, in the case of occupational health, quite a doctors, insurers usually request reports from all healthcare professionals who treated the patient in order to determine compensation. How do we deal with this matter, considering the POPI Act?
You get the patient's consent.
Okay, so as long as the patient consent to providing, and it must be in writing, preferably. No? Okay,
I mean, it's in their interest to get the compensation. So, but just get it and document that you obtain the consent.
That's right. There's a question. It says you talk about life and limb emergency. Is other organs such as an eye?
Yes.
So when
we
you talk
always
about
talk life and limb, but it applies to any other organ. Yes.
That's right. Okay.
Yeah.
Interesting question, but I'm sifting through the questions. Prof, you can pick up any of the other questions remaining. How much time do you have? Another 5 minutes or 2 minutes?
I've got 5 minutes. In order of preference, can the proxy be the sibling when the adult child is available? It should be the adult child. It says that in that order in the National Health Act.
Okay. Can consent be obtained from patient by using computer-assisted translation?
Yes, as long as there's somebody, I mean, how do you know that it's an accurate translation? And that's what always worries me, these computer-assisted translations, especially when it comes to medical things and intricate surgical things, you know, chemo, all those sort of things. So yes, of course it can, but I think one must just be circumspect and know that these computer assisted, some translations are very good, but I don't know how one checks on the accuracy of them. So that would concern me.
Yeah. And there's one from Tamanelli who's asked that how is patient's capacity affected by benzodiazepines? I suppose that is, I think you covered it a little bit.
It's covered. It's affected. It depends on the patient. It depends on the dose, but it is affected.
That's right. Yeah. So any form
so you shouldn't
of what
get
could be.
Sorry.
Yeah. Continue, Prof.
You shouldn't get consent if they've had a benzodiazepine.
Yeah. Or any pre-medication that may be given. Then it's risky. All right. I don't see any other that I think we need to attend to. But if there are any questions that are still remaining that we've missed, we apologize for that. But please, we will go through the list and we will still put them to Prof Lundgren even after today. And when Prof finds time, she can always attend to them. So those who have other questions or comments may just drop them on by email on webinars@clinix.co.za, and we'll pass them on to Prof Lundgren. I think at this time, it's time, Prof, for me to thank you profusely for your expertise, sharing your expertise at all times and on many occasions. I mean, I interact with you regularly in another setting. You are one of our people, professors who assist us in the country, wholly, several institutions, and also we've consulted you in our clinical governance committee, and to ensure that the hospitals within clinics, you assist clinics to ensure that there's quality and safe patient care within clinics facilities. And I think we are one of those who do that. You've been doing that for some years, and I think it's appreciated. You offer that to other hospitals as well, including the hospital where you work at the Donald Gordon Medical Center as head of clinical governance there currently. Post-retirement, I don't think you will ever retire or be allowed by the health system and academia to retire in this country. We use so much, even at HPCSA. Still, we really appreciate it, and we wish you well in your health. We need to keep you for the sake of the health system in this country, quality of health, and for the patients in this country. We really appreciate your efforts. I would like just to thank all of you attending. I think as I said earlier, at the top I counted 706 attendees. We still, even at this late hour, have some people still logged in. About 500, over 500 up to now. At 1 hour, 45 minutes after logging in. And I think that's amazing. We really appreciate it. We will have another webinar next week, Thursday, same time, same day. We will let you know within the next 2 days who the speaker is. We have another speaker also lined for the following week, the 5th and the 12th of February. And as I said, if any of you would like to offer any talk with your colleagues on this platform, please contact us on webinars@clinix.co.za. I can also give you my personal number, 082-449-7678. You can just drop me a WhatsApp text message and I'll contact you. Thank you very much. Thanks, Tolakele and Sam in the background who assist me technically.
Yeah, thank you.
Thank you very much and good night to everyone.
Thanks, Dr. Kinoshi. Thanks, Sam. Thanks, Tolakele, and thanks, everyone. Bye.
Bye.